I've just been told how to use a microphone, for which I'm grateful. My name is Dominic Preston. I'm a member of Chambers and a barrister doing housing. I do a bit of quarter protection and other things as well. I wanted to welcome our three speakers, but before I do so, I'm just going to give a slight synopsis as to the two seminars that we're doing. This is the first part of a seminar on supported accommodation. We realized the topic was slightly bigger than we'd anticipated. So we're doing a second seminar later on possession claims. And this seminar, we are going to concentrate principally on what you might call the broader picture, trying to work out or trying to explain the sorts of clients who might require supported accommodation, the context, possession claims, homelessness allocation, community care, court protection, that you might either meet those clients or want to take those clients. And the hope is to give you a sense of how to support those clients. They are difficult to manage because they have complex needs very often, particularly with mental health. How the variety of jurisdictions overlap and connect, and to identify and perhaps solve, I rely on the speakers for that, some of the problems that you might encounter as you're going through it. And on the next occasion, as I say, the date is 11th of June. We will deal with perhaps a bit more nitty-gritty on the possession claims and the rights of security of tenure that these sorts of clients might have if they do have accommodation. I've got with me three excellent speakers, Marie Paris, Alice Irving, and Laura Coyle. And I'm going to spend just a few moments to introduce them. I hope you'll forgive me. I think the easiest way of introducing Marie is to say that she shares the curse that all housing lawyers seem to have, and that's the curse of actually enjoying housing law. I speak about it to other people and they look at me strangely and then I walk away. But housing lawyers think differently. And on that topic, I did want to mention one particular housing lawyer that we will miss, Charles Peaker. I'm sure many of you have heard. I have beside me Laura Coyle, who is the current co-chair of the Housing Law Practices Association. I'm sufficiently old to remember the times when Charles gave me a hard time as when he was chair of HALPA, and we were all sitting there going, perhaps we should work harder and do a little bit more than we thought. He was a hard taskmaster, but he was really amazing at putting housing law at the centre of so many people's lives. So just thinking of the legislation that he dealt with and that he pushed through with the last government and with this. We'll miss him. I mentioned Marie. I mentioned her curse. I apologise for doing so because I share it. I'm going to just introduce Laura Coyle, if I may. She is the partner and head of housing at Turpin Miller. There are advice deserts all over the place, and I'm not entirely sure if there is another firm in Oxfordshire or in the environs, but she holds her own in the face of a heavy workload, I think. She is co-chair, as I mentioned, of the Housing Law Practices Association. She describes, well, I'm going to describe her as a lifelong activist. She might not do so, but if I tell you that she started as a local councillor in Haringey and then realised that, in fact, all she was doing is referring people with housing problems to lawyers, she thought maybe it's better if I was one of those lawyers. She is passionate about what she does, and I know that from personal experience. She has a particular expertise, in particular in relation to today, working with clients with mental health issues. And I should say, she is still a local councillor, even if in a different ward. Alice Irving has a wide public law practice. Indeed, you might think that she does so much that she would spread herself too thinly across the many fields of her expertise, but she really is a powerhouse of energy and skill with a formidable reputation. In case that wasn't enough, she's also managed to find time to get a few master's degrees and even a doctorate. So hopefully she won't be questioning me too hard. I'm grateful to all three for giving up their time. Grateful to you all for attending. And with those instructions, I hope you'll forgive me if I move straight on. Marie, I think you're starting.
Hello, everyone. Hopefully you can hear me. Yeah, cool. So I'm going to be covering the first aspect, which is kind of just the sort of introduction to supported accommodation and less about the supported accommodation itself. And that sounds a bit strange, and more about the context for when you might need it. So in the midst of possession proceedings is probably the most common one, when somebody comes up to you and you're not sure what kind of needs they have, and how Alice is going to talk to you about the community care side of things, but broadly how to get it. So in the context of possession proceedings, what can you do to work out if your client actually needs supported accommodation, and what can you do to try and get the landlord to help you out? So there we go. I've just breezed through that. So as an introduction, when do you need to be thinking about supported accommodation? So there's lots and lots and lots of different kinds of supported accommodation, and we may be talking more about that in session 2. But broadly speaking, it's obviously when you have a client that's not doing too well in general needs accommodation or has no accommodation at all. So you've got homeless clients. As I say, the most common issue is probably going to be clients who are facing possession proceedings, clients who aren't yet facing possession proceedings, but clearly aren't managing where they are. And in the midst of all that, I'm turning my phone off, clients who lack capacity in various domains. So we'll talk about that in detail now. As I say, where it comes up the most often, certainly for me, is when you have a client that everybody agrees is disabled, everybody agrees has some sort of support need, but nobody knows quite what to do with them in the accommodation that they're in. So obviously, when we talk about disability discrimination, normally in the context of antisocial behaviour, hoarding, rent arrears, any of the sort of various breaches of a tenancy agreement, the hope and prayer that we all have is that we put in these defences, we get directions that are going to take you 6 months to a year to comply with. And in the meantime, you're going to sort out whatever the problem is. And that person's going to be able to stay in the accommodation and prove to the court at trial, if it gets to it, and hopefully you don't get to it, that the breaches are over. What I needed to happen is now in place, and I'm now a good tenant, and you don't need to evict me. But there are going to be, and our most difficult cohort of clients probably, there are going to be times where that's just not possible in general needs accommodation. So what do you do to identify that early, the possibility early, not necessarily give up, but the possibility of it early, and to try and get it sorted before you hit a crisis point and you're really close to eviction? Because the last thing anybody really wants is for people this vulnerable to be on the street. So how do you get the issue to be at play? So I think everybody here probably knows a fair amount about disability discrimination in possession proceedings. I won't go through it in detail, but the point is the question of supported accommodation and the availability of it, I think, comes up anytime you have proportionality in question. So how do you get that in? You have your classic Section 15 defence, where you say whatever breach is alleged, if you manage to prove it, arises as a consequence of the disability. Unfortunately, that's not the end of it. It has to be, the means chosen have to be a proportionate means of achieving a legitimate aim. So that's where you start to think about supported accommodation. And then you can also bring in Section 19, a little less common because you have to find a PCP, a provision, criterion, or practice, and essentially say that the landlord is applying it evenly, even though in a way it affects disabled people more, or whatever group you're using. But the point is, when that happens, as Lady Hale says in Acomb and Livingston, it's for a landlord then, it shifts onto them, the burden shifts onto them to show that there are no less drastic means of solving the problem than whatever means are chosen. So that's issuing a notice, that's issuing the proceedings, and then right at the end of it, it's choosing to still pursue possession proceedings after whatever has happened over the course of the litigation. So even for cases where the behaviour is very, very serious, as I say, and you can't find a way to stop it, and difficult to deny. So, Everyone here has had allegations of antisocial behaviour that is horrendous, but turns out not to be true. But I think most of us, when very serious allegations are made, you have to start thinking about whether that's true or not, and most of the time it is. Otherwise, there's no reason for the proceedings to be brought. Depending on the type of landlord, there should be a consideration at some point of whether alternative accommodation can be found. So even if everyone agrees you've got to go, whether there's something else that you can be moved into, and whether that can be provided before the eviction. And that to me is first, the landlord needs to do that in order to satisfy the proportionality test, but also comply with the PSED. So those two go hand in hand. Considering what the disability is, how it affects you, and how homelessness is going to affect you, and what you can do about it to prevent it. It requires a consideration of what the defendant's housing needs are. And that's especially the case, and I think lots of us will have seen this where, and certainly me and Laura have seen it in certain cases where the landlord says, look, obviously the housing needs aren't being met. You require a level of support that we can't give you. Well, then you say, is it enough really to say you've got to be evicted and you have to be on the street? Is there something that can be done by the landlord or by you in order to have those needs met? So, possible lesser measures fall into three broad categories. Obviously, these are lesser measures that involve leaving the accommodation. There's lots of lesser measures you can have from within the accommodation, but this is for when times are really tough and you think there's no way that we can stop the breaches of the tenancy agreement without something drastic. So the first is getting the defendants or whoever resident is there care needs assessed under the Care Act 2014, and Alice will take you through the basic framework of that. The point there is obviously that's much more helpful when you've got a unitary authority and the landlord is local authority, but you can still be making the case that a social landlord, things like that, should be sort of an independent housing association should be making that referral themselves, or a little taster of what's to come, giving you time to make that referral yourself and pursue it. If relevant, and I'll talk about when it will be relevant, a referral to the Court of Protection. Again, much easier if the landlord is a local authority with that has social services. But again, it's something that you can say needs to happen. And if you flag it as an issue early on, even if the landlord's not a local authority, again, it's about getting time to make that referral yourself. Or an assessment of the defendant's housing need under the Housing Act 1996. That's a bit more difficult because, that's a bit more difficult as it's not necessarily how you get supported housing. But as I say, there are sometimes, and I think there's people in this room maybe that have worked with me in cases where through a homelessness application, you manage to get them on the path to supported housing. So this is a word of warning in very densely written text. This is a case called Diamond RHP. It's a Richmond Housing Partnership. The reason why I have those quotes out there, so this is a case where the the High Court on appeal said it's not necessary for Richmond Housing Partnership as a social landlord to have taken all these various steps that Mrs. Thiam's solicitors and barristers suggested they need to do in order to satisfy the court that the measures were, that eviction was a proportionate means of achieving a legitimate aim. So three of the quotes here tell you how limited the court found the requirements to be in order to satisfy proportionality. So this is about section 15. I do not consider the obligation to act proportionately imposed by section 15 required Richmond Housing Partnership, which is a social landlord but not a local authority, to engage specialist help for the tenant. So in that case, that was specialist help about hoarding. Taking that step would go beyond anything ordinarily, or in the circumstances of this case, within the reasonable ambit of the landlord-tenant relationship. That's the responsibility of social services department rather than the landlord. It will cost RHP too much money and it's not proportionate. So they're saying, that's basically saying, yes, if there are lesser measures, they should be considered, but they don't, it's not going to be the case that a landlord is always going to be required to do every possible lesser measure available, even if it looks like it might work. If it's too expensive and costly, the court's not necessarily going to expect them to do it. And the sort of last gasp for Ms. Thiam was that they were arguing, look, if a person may lack capacity and the hoarding, in that case, the hoarding behaviour is continuing, well, there's one final thing you can do before evicting her, which is pushing for an application to the Court of Protection. And the High Court said, no, we do not agree with you. Basically, and you can read these quotes in detail yourself. I won't read them out to you, but essentially, what the court didn't like was that RHP is a social landlord, not local authority. But more importantly, what they thought about all this is that it was all coming rather late, right at the trial, and it was all very speculative at that point. So in this case, it wasn't clear whether capacity was actually an issue. It wasn't clear whether she actually lacked capacity, truly. It wasn't clear what sort of application would have been made to the Court of Protection. It was just sort of vaguely said that you can make an application to the Court of Protection. And because of that, it wasn't really clear that that application to the Court of Protection would achieve anything. So how do you get around that? I think the main thing to do, practically speaking and sort of legally speaking, is raise everything as early as possible. So make it so it's not speculative, because I think in lots of these cases, the fact that you have a tenant that is doing sort of extremely unusual things in the property, and I think we've all seen that. So short of violence, but leaving the property in a real uninhabitable state, and you're wondering how on earth they've been there for that long. Raising hell with the neighbours, screaming, shouting, all that sort of thing, that is not somebody who I would assume to have capacity. So a lot of the time, this will be a real issue. And the point is, for me, raise that issue as early as possible. So that can be on duty, but most of the time that will come in the form of a disability defence. So make it clear bright and early that there are other measures that they can take. The most important thing is getting a detailed expert opinion. I try every time, if there's a possible issue of capacity, to get the expert applied the possession proceedings to comment on it. And sometimes landlords really kick up a fuss about it. But it's just cheaper. And as soon as an expert has commented on it, it becomes a live issue. It's no longer speculative. And it's also something you can use outside of the possession proceedings to get social services most of the time to get moving on an application to the Court of Protection. And on that note, use the expert report to be proactive. So be proactive about your referrals to social services, the homeless department, and do it early. Don't do what happened in Mrs. Thyam's case, and I'm sure there's lots of reasons why it happened in that case, but for our purposes, try not to leave it, but please don't leave it until the day of the trial, because the court's not going to be satisfied then. Even if it is the case, literally, that there are things that the landlord could have done that are lesser measures, it becomes much less attractive if you say that on the day of the trial and you've had 2 years of litigation kicking around. Make the referrals early and pursue them. So don't just drop an email. Try your best to pursue them. And hopefully Laura's going to be talking to you a bit about what you can do to extend your legal aid as far as it will go, because I'm sure that's a concern for everybody. But even just getting it on the radar, you make the applications, you already look like you're being much more responsible than the landlord, and the landlord starts to look at like there were things that they could have done that they didn't do. Questions to the expert. So I'm sure everybody has done instructions to an expert on disability discrimination. And you probably already know most of this stuff, but just because I've had a horror story lately with an expert absolutely determined to say that somebody who had about 4 different overlapping lifelong mental health disorders was not disabled somehow. This is what you have to do. You have to be as clinical as possible, to the point of being a bit boring. When you're asking them about each aspect of the definition of disability, spell it out for them. So what's the impairment? What's the substantial adverse effect on the ability to carry out daily tasks? So what are the impairments? How long have they had them for? How long are they going to have them for? The effect on several different kinds of daily tasks, so list them. Paying your rent, managing your emails, managing your correspondence, speaking to neighbours, speaking to professionals, seeking help where you can get it, getting up in the morning, cleaning your house. And most importantly, the extent of the adverse effect. So, there's not much ways you can spell it out, but ask them on a daily basis, how are they affected? Obviously, what you need to do to make out a Section 15 defence is you need to get the connection to the breach of the tenancy agreement. We're often arguing that doesn't need to be the primary cause. It just has to be a contributing cause, the disability that is. It's helpful to put in suggestions or ask suggestions for support that could improve the behaviour. Get that there out nice and early. Lots of experts aren't going to know what sort of options are available, so give them some options and ask them if they're going to be effective. And the landlord will say you're leading the witness, but who cares? At least it's helpful. And then, as I say, I think it's very important where the issue arises to get this out nice and early. It's questions about capacity. So obviously capacity is issue specific, but most of the time when it comes to clients that might need supported accommodation, it will be in respect of things like hoarding, and then capacity to make decisions in respect of residence and care. So, basics of capacity. Oh, you've come to Doughty Street sessions before. You will have heard me or my colleagues, especially Dan, talk about capacity. But here are the basics. It all comes from the Mental Capacity Act 2005. Essentially, capacity is issue specific. There is a presumption of capacity. Well, there we are. There's the classic things where you can't say that somebody's making an unwise decision automatically lacks capacity. And if somebody lacks capacity, anything that has to be done under the Act has to be done in his best interests. So that's section 1. Section 2 is the test for capacity. So you have an impairment or a disturbance. It doesn't matter whether that disturbance is permanent or temporary. And then with a bit more detail in section 3, what is it that makes somebody lack capacity? They cannot understand the information relevant to decision. They can't retain that information. They can't use or weigh information as part of the process of making the decision, and they might not be able to communicate the decision. So obviously that's or. If they're not able to do any one of those, they lack capacity. And that all sounds fairly straightforward, but when it comes to different aspects in housing cases, it can all get a bit complicated. And one issue that I see a lot, especially with clients that might need supported accommodation, is this question of you have a client that seems to be, it happens a lot, very eloquent, can fully understand or seems to fully understand everything you're telling them. So say a person who hoards in the property can understand that it's a fire risk, can obviously understand that they're at risk of losing the house if they don't get rid of various hoarded items. But you and I both know that they actually wouldn't, push come to shove, be able to make, to move those items, even if they know they're about to lose their house. So this case is quite helpful. It's RERGS. I often put it in my instructions to the expert because it often makes an expert see things in a slightly different light, because experts are really quick to say, no, this person seems to understand what's going on, so they must have capacity. So a person may understand the relevant information. They might be able to retain it. They might intellectually be able to acknowledge its significance, but be unable to give it any proper weight because an overwhelming phobia, obsessive thoughts, compulsive behavior, or abnormally impulsive behavior attributable to an impairment or a disturbance of the mind. So this case is specifically about litigation capacity. But it also extends to subject matter capacity. This idea that you might intellectually be able to understand what's going wrong, but not actually be able to make reasoned decisions about it because something is overwhelming your capacity to make those decisions. So when you're putting questions to the expert, trying to get this out in the open as early as possible, what sort of questions do you need them to answer? Does your client understand the terms of the tenancy agreement? So think about what's in the tenancy agreement. Can they manage their rent? Can they manage to pay the rent on time? Can they manage to keep the property in good nick? Even if they do, can they actually comply, or is there some impairment preventing them from making reasoned decisions that would allow them to comply? So that's the RERGS point. Does your client understand what different options are available for accommodation? And that's a much more broader issue than that might be immediately obvious. So do they understand broad information about the area? Differences between visiting a place, actually living there, whether they can get support there, what's expected of them if they lived in different areas, managing their rent and bills, and generally their different obligations. Can they make reasoned decisions in respect of those options? So even if they understand the options, can they actually weigh up where they want to go? For instance, you might have a client who's a hoarder that wants to be left alone because they want to be able to hoard in peace. Well, are they really making reasoned decisions about that if they've got the option to move in supported accommodation where somebody will be monitoring that? Obviously, they don't want to go because they don't want anybody to get in the way of their hoarding behaviors. But is that really a reasoned decision? And can your client make reasoned decisions about care? And I say this because what will often happen, and what was relied on in Thiam, I believe, is, well, we made all these referrals for her, but she doesn't want to engage. She doesn't want to go and be assessed. That seems like a get out of jail free card for a landlord, but the question really is, do they have capacity to make decisions about that? So that is good to flesh out with the expert bright and early, as I say, early doors. What can the Court of Protection do? So obviously I'm not a Court of Protection practitioner. Dominic next to me is. But broadly, in terms of what we need to know about it, the COP can make determinations as to whether your client has capacity in various domains. So as I say, capacity is issue specific. If there's a dispute about that, which may well arise from the expert report. So sometimes you'll get a client who's been assessed by social services as having full capacity to make decisions about everything, whereas your expert thinks that they lack capacity in lots of different regards. Well, if there's a dispute, that should go to the COP. And the very helpful thing is if they do lack capacity in certain domains, such as what types of residence and care you can get, the COP is there to help everybody make decisions from available choices as to what's in the client's best interest to accept. So that can, of course, include supported accommodation. But practically, the real benefit of the Court of Protection, even though it really should just be an exercise about helping everybody make a decision amongst available options, the Court of Protection, in my experience, if you get them involved very early, so what you can do is ask for a stay whilst various authorities are making applications to the Court of Protection, or you can ask for a judge with a joint civil and COP ticket to be in charge of managing the case going forward. That's particularly helpful. What the Court of Protection can do is put pressure on various agencies to bring options to light. So they won't just say, in my experience anyways, they won't just say, oh, there's no option, so what can you do? They will say to social services, look, is there not something else that you can be doing? They will also say to in my case, a housing association, not a social landlord, look, what other options of available accommodation have you got? And maybe social services can give support in that general needs accommodation. And the whole time they will be doing it, in my experience, with a much kinder approach to the client. So they're much more used to dealing with clients that lack capacity. And it's much less adversarial than normal housing proceedings. So if you can get the Court of Protection involved, do so early. And what I will always do in cases where it seems obvious that this is going to come up is plead in the defense. Plead in the defense. An option that the landlord can always take that's a lesser measure is as soon as something arises is to agree to a stay or a long adjournment for the Court of Protection to do its thing. And that becomes a very simple thing for the landlord to do. Obviously, that's going to be a bit more difficult if there's ongoing violence or things like that. But as long as you raise it early, it looks like a realistic option. The Court of Protection is much less of a blunt instrument than civil proceedings, possession proceedings, where the court can kind of only either kick the claim out, adjourn it, or kick the client out. It just seems much more sensible that you push things through the Court of Protection, where there's lots of different options that can be fleshed out. So that is my whistle-stop tour of how to get the issue of supported accommodation live nice and early. And then Alice is going to talk to us about the Care Act, I think.
Marie, I'm going to interrupt very briefly. Alice, hang on 2 seconds. 2 points I wanted to pick up on COP, because they're probably the right place to put it in part because you'll hear from Alice how difficult JR is. The two advantages of the Court of Protection, the first is anybody can apply to the Court of Protection. In consequence, anybody can be forced to apply to the Court of Protection. You can say it's not proportionate unless the landlord applies. I know the case of Tame, we've got to deal with it, but that's the advantage procedurally, is that the official solicitor will very often say, well, that's a very interesting theory, but I'm not going to help you because I don't do anything without my costs being covered. But you can ask for the stay, as Marie was saying, in circumstances in which the stay is for the purpose of the landlord to apply. Doesn't always work, but there is a procedural advantage. The second bit is, and this really does tie into what you're going to hear, I think, from Alice, it's the Court of Protection shines a very, very bright light on local authorities, and they often buckle for good reason, because they're very often well-intentioned social workers. They may be struggling, but they do generally want to help if they can. And if the Court of Protection says, well, it clearly isn't working at this property and the alternative is homelessness, can we work out what the other options are when they turn up at your door? And could we have those options now rather than when they turn up at your door? So there is that second advantage. Can't force something that the local authority doesn't want to do, but can shine a light saying, is this really the position you're taking? And it works well, not always. Lots of cases where it hasn't worked. However, the reason why it is important is because the alternative is the rather hard-edged black and white law of judicial review, for which, Alice.
So what I'm about to say might be superfluous because judicial review is a bad idea. No, I'm joking.
No.
We're going to start with just the framework of the Care Act to give you an overview of how it is that you might get accommodation under this regime. And this is the route to supported accommodation through social services. I'm going to make a couple of comments after that about things you might want to point the local authority to in relation to assessments, particularly where you get that argument that Marie mentioned that we see all the time. Well, we tried to assess, but they didn't engage. And then just one observation about the eligible needs that might be useful when you're pointing the local authority in the right direction. Accommodation plus, so that's about the test that applies to determining whether you can get accommodation under the Care Act as opposed to, say, under the homelessness regime. And then finally, a little bit about the interface between social care and the homelessness regime, because you'll find that the two departments are going to want to push you off onto somebody else. And then I've got a final slide that has bullet points that are not developed about the interface with other systems, so asylum support and healthcare, things like continuing healthcare, mental health, aftercare. And then I'll speak a little bit about if you've kind of tried to go through this route and you've got, say, a Care Act assessment that's really poor, the kind of judicial review angle that Dominic is talking about and the very real challenges in relation to that, which is why he's quite right that if you can get it into COP, it's often a much better option. So this is going to be a whistle-stop tour. I'm sure that many of you are very familiar with the Care Act. So just bear with me as I sort of take you through the key points. Don't forget about Section 1, which includes the overarching duty to promote an individual's well-being. It also includes a whole bunch of really actually wonderful principles about involving people in care decision-making and listening to what they say about what they need. The kind of ethos of the Care Act is actually really good. It's about meeting needs, not just kind of pushing people into whatever services are available. That's the theory. In practice, it doesn't really work like that, but there's still some useful stuff. I always open up Section 1 and see if there's anything in that I can start any kind of letter with to a local authority to set some mood music about how they ought to be thinking about things. And you'll see that the definition of well-being there is really broad, and it does include reference to the suitability of living accommodation of a person. Okay, so when is a local authority required to assess somebody? Section 9 is the assessment duty, and all you need is that an adult may have needs for care and support. So that's a low threshold, and they should not be gatekeeping around assessment. You should be able to set out quite clearly to them, here's the basis on which we say there may be needs to care and support. This duty is triggered. You now need to assess. I'm going to come back to this, but just while I'm going through the sections, Section 11 has some specific important provision around refusal of assessment. Normally, if somebody refuses an assessment, a local authority should respect that, and they're not required to complete an assessment in accordance with the Section 9 duty. But that doesn't apply in two circumstances. The first is one that Marie mentioned, which is why it's important to ask your expert about this when you're instructing an expert, which is they might not have capacity to make a decision about whether to be assessed at all, and to determine whether it would be in their own, best interests. So that's one situation in which a local authority can be forced to assess in the face of a refusal or a lack of engagement. Engagement is my least favourite word in all of these cases. The second, which is really useful when the capacity position hasn't really been bottomed out yet, is where somebody's at risk of or is experiencing abuse or neglect. So if you've got a case where you've got somebody living in a property with really serious hoarding, often they're self-neglecting quite seriously. And so neglect there includes self-neglect. And you can lean on that again to say, even though this person is not engaging, you still have a duty to assess. So when an assessment is carried out, what the local authority must do off the end of that is set out in section 13. To begin with, we sort of go through the regime. They need to decide whether a person has needs for care and support, and then if they identify needs for care and support, they need to decide if any of those meet what we call the eligibility criteria. Those are effectively the nationwide criteria that apply to say, well, is this something that a local authority has a duty to do something in relation to? So do they have to meet these needs? And this is one of the great benefits of the Care Act in comparison to the very old legislation around children's social care, where it's basically local authority area by local authority area can, in a sense, kind of exercise a bit of discretion around which needs they meet and what eligibility criteria they apply. There is centralised eligibility criteria under the Care Act, and it's set out in the regs. There are effectively 3 requirements. The regulations are really short and quite simple, so this is just a bullet-pointed summary. The needs for care and support you've identified need to arise from or be related to a physical or mental impairment or illness. That's often not really an issue. Because of those needs, they need to be unable to achieve 2 or more of the specified outcomes, which we'll get to in a second. Now, what's really important is unable to achieve. When you assess that, you do it in a way that's carer blind. So you don't take into account any support they're actually receiving. You look at the individual on their own. Can they do it? Can they meet these specified outcomes? Can they do it without assistance? But even if they can do it, does it cause them significant pain or distress? Does it endanger health and safety? Or does it take them significantly longer than you would normally expect a person to do it? And if any of those things apply, then they're unable to achieve. It's not a binary, can they or can't they? If it's really hard or it's really painful, they will still qualify. And then the final stage is the fact that they're unable to achieve 2 or more specified outcomes. Because of that, are they or are they likely to be a significant impact on well-being? And that's where we loop back to section 1 and that really broad and lovely definition of well-being, which is useful. Again, normally the third criteria, frankly, is a bit of a tick box. It's this middle bit about unable to achieve 2 or more specified outcomes, where a lot of the legwork is really done in these assessments. So the specified outcomes, there's a really big long list, and I'm sure you're familiar with them. I've just pulled out some of the ones that might be most pertinent in the kind of cases we see as housing lawyers that we'll be thinking about. So if we're thinking about the kind of possession cases that Marie has mentioned, and we're thinking about, for example, a hoarder, obviously making use of the home safely and maintaining a habitable home environment are going to be relevant. If we're thinking about ASB, we're also going to be thinking about personal relationships. Those are things that they often don't think about. And I'll talk a little bit more as well about how maintaining a habitable home environment can be useful in even broader range of cases than you might think. So you need 2 or more specified outcomes if you get that kind of tick box, and then the impact. The local authority then has a duty under section 18 to meet eligible needs of care and support. Now that's subject to a residency requirement and a bunch of stuff about financial assessment and charging I don't want to get into. Normally for the kind of clients that we're working with because of legal aid, that's not an issue. Just to flag, section 19, there's a power to meet needs for care and support, which includes non-eligible needs, so on a discretionary basis. But for our purposes, the bit that might be useful is sometimes you can say, look, you need to do something pending completion of assessment because this is, things are carnage. Just be aware that that is there, and it's something you can ask them to exercise the discretion to provide some interim support. So if you get to the point where they've accepted there's eligible needs and they have a duty to meet them, then they have to prepare a care and support plan, which is the document you end up with. And there's a whole bunch of stuff that has to go into that, but what's most important for us is that they need to identify the needs they will meet and how they're going to meet them. And it's really amazing how many of these documents do not do this. a lot of the time what you end up seeing is something which is like, we recognize all these eligible needs. We're now going to go and think about how we're going to meet them because we don't really know what we have. And particularly when we start talking about people who need supported accommodation or who have complex needs, this is where flushing out what options are actually available and getting the local authority to pin it down can be really difficult. So I see lots and lots of assessments that say, this person might need supported accommodation, but we have to go through our brokerage. We're looking for a placement. We haven't found anything. We're not really sure. And so practically speaking, it's not generated something concrete. And that's where sometimes you get stuck and where being in the COP can really force things forward. In terms of how they meet needs, Section 8 is the provision that tells you that one of the ways you can meet needs is to provide accommodation in a care home or premises of some other type. So that is what gets you the broad ability under the Care Act to provide accommodation that is not just in a care home. So sometimes local authorities say, oh, you're only going to get a care home under this. Not true, Section 8. Okay, so that's the kind of rundown of the overview of the legal regime. The Care and Support Statutory Guidance, which is online, is really, really thorough and helpful. And again, whenever I've got a case, I always just go back and read through the relevant sections, because there will be something here generally you can pull out and like weave into any kind of letter or submissions. So a few practical pointers on assessments first. This issue of a client not engaging. I mentioned earlier the Section 11 duty to complete an assessment if a person lacks capacity or if they're at risk of neglect. See also the guidance 16.20, which it basically repeats this. The other thing to really think about with a client is whether there are any things you can ask of the local authority to facilitate assessment and engagement. Because often what they do is they say, well, I tried to ring them or I turned up and they didn't answer the door, but they're going about it in all the wrong kind of ways, exactly the kind of way that the sort of clients that we're talking about are just going to freak out or like refuse entry. So there are various things you can do. You can say that an assessor should have a particular qualification. Now that can be kind of tricky. If you think somebody has really particular complex needs or communication needs, you can say, look, can I make sure that the person who's trying to assess this person actually has experience, say, working with somebody with this kind of profile? There is specific provision for people who are deaf-blind around qualifications, which isn't generally pertinent here. So you can ask, that's normally a bit in terms of the likelihood of getting it. Supported self-assessment can be a really good option. Local authorities are often not keen on it, but basically there's a whole section in the guidance as well that explains what this is. A person can fill out a form on their own, and then the local authority will triangulate with other information and so on to complete an assessment. So if a person has trouble meeting people, new people, or building trust, but they trust you, that might be something you can support them to do. You can suggest an online or a phone assessment, again, if that's more helpful. You can try for a joint assessment, although often that just means you're trying to deal with two sets of services who are not functioning well. Sometimes you will have clients that have communication needs. I had a client recently where we got the local authority went off and got a speech and language therapy report about how, or very brief advice about how to communicate with the client, because she was autistic and there were very particular needs about how to communicate with her, and if those weren't sort of adhered to, things would be shut down in terms of her ability to engage. And all of this can be framed as a reasonable adjustments angle, and that's referred to in the guidance. So things are asked for: meeting in a familiar place, so maybe hosted in your office with a support worker that's familiar with them present, not in the morning maybe if they're struggling with that kind of stuff. Now, if a local authority, you've put that all in writing, and then they try to rely on the fact your client hasn't engaged, when you're later challenging their failure to do a Care Act assessment, obviously you've set up a challenge that looks really reasonable. You said, we've told you how to engage this person. The guidance tells you you need to think about how to engage people, meet them where they are. You failed, so you can't rely on my client being difficult. Other sections of the Code of Guidance that are really helpful, independent advocates. Some of what the guidance says is if there's like a third party that might be able to support, so a family member or a friend, again, or a support worker from another agency, you can be talking about whether they can be there and helping. But in particular, where somebody might lack capacity, you are probably going to be asking the local authority to appoint an independent advocate who's just another person who can be helping kind of push things forward and also making sure that the person's interests are represented. So there's just some bits of the guidance there to refer to. One of the things I like to point local authorities to if I've got a housing case where I'm trying to get them to accept that there are eligible needs is this bit of the guidance. Often when they think about maintaining a habitable home environment, they just think about, is it clean? That's fine for hoarding cases because you don't need to disambiguate that. But if it's, say, an arrears case or where somebody's really struggling to manage their life, or it's sometimes an ASB case even, sustaining occupancy of your home can be a hook where you can say, look, the fact we've got these possession proceedings and all of these things are going on tells you they require support to sustain the occupancy of their home. It doesn't always work, but I tend to underline that when I ask for an assessment, because otherwise often they miss that and then you have to challenge the first assessment you get. Okay, so when can you actually get accommodation under the Care Act? It is not a case that you can just sort of poodle over, because we're talking about a supported accommodation. Obviously, that's not what we're suggesting, and say, I want accommodation under this regime, please, instead of this one. It's not a sort of picking and choosing. When you're looking at the Care Act, you're looking for somebody who has accommodation-related needs. So the services that need to be provided to meet the care and support needs are either accommodation-related, or in another case, the language is accommodation plus. So in this case, SG, and I can't say Irving, and I get teased about it. I teased about it by my office mates all the time. The accommodation-related care and attention kind of definition says it means care and attention of a sort which is normally provided in the home and will be effectively useless if the claimant has no home. So this is obviously quite useful if somebody might fall outside of eligibility under the homelessness regime, but we'll get to that in a second. If all you're really, if somebody could get general needs accommodation through some other route, because they're, say, eligible for Housing Act stuff, you wouldn't probably be pushing here. But if we're talking about supported accommodation, we're obviously talking about something that's above and beyond the kind of support and care somebody can get in a general needs unit. So we might be talking about somebody who needs somebody to be on site around the clock, monitoring, dropping in every now and then, and a visiting carer is not going to be adequate. You might even, in really complex cases, need some kind of deprivation of liberty. And these are all kinds of things that you can't really, that are obviously interconnected with accommodation in a way that means you can say this is Care Act territory. Aberas is the most recent, one of the recent big cases on it. And this is Fordham doing a classic Fordham and summarising everything. So paragraph 6 is quite fun. So he takes some of the language from Lady Hale and older judgments, where he basically says, when we talk about care and support needs, we're talking about a looked after need, which is a bit of a, I don't know, I don't like the language, but, and basically he says, look, accommodation in and of itself is not a looked after need, so a need for care and support. So just rocking up and saying, I need accommodation, you're not saying something that makes sense in the context of the Care Act. But you might be able to get accommodation where it's necessary so as to secure effective care and support for an eligible need. So it might be necessary as an appropriate conduit for the practical and effective delivery of care and support for the relevant looked after needs. So again, when we're thinking about supported accommodation, it's going to depend a lot on the type of supported accommodation, but often we're talking about the need for ongoing monitoring, to maybe help people with interpersonal relationships, maybe to prompt people to self-care. It might be clearing during the day for hoarding. It might be a young person or care leaver who just basically isn't able to manage their own household without sort of somebody around to keep an eye on them. That's the kind of thing, again, that we're talking about, practical and effective delivery of a type of care that you're not going to be able to deliver in the right sort of way in supported, non-supported accommodation. Same thing again, basically. Sometimes this is referred to as accommodation plus. So that's where you get this language of accommodation plus. And basically at the end, a bit of a warning shot, which is it's really important to maintain a disciplined focus on the looked after needs, because there is a distinct statutory regime in relation to general needs housing, so the homelessness regime, And the Care Act is not a backdoor route to get accommodation. And that's something the courts are really, really wary of. So you need to do your legwork to make really clear that this isn't you just trying to get around the failings of the homelessness regime or the allocation regimes. And again, that can go to the kind of questions you're asking an expert. You might sometimes, depending on the expert, ask them for their views about a person's abilities around the eligible needs kind of framework. And sometimes you can be asking them, when you ask what kind of support might be necessary, if you can draw them into saying something that's helpful along the supported accommodation line about why this person might need something that can't be delivered in general needs accommodation, that can help you to avoid the charges of trying to just circumvent the Housing Act by asking for things from social care. Which brings us to the interface with the homelessness regime. The key section is section 23 of the Care Act. A local authority under the Care Act may not meet needs in discharging their duty under section 18 of the Care Act by doing anything they are required to do under the Housing Act. So that applies to both Part 6 and Part 7. If under the homelessness regime, they are required to provide somebody with general needs accommodation, then you're not going to get it under the Care Act, because it's not just the case that they shouldn't, it's that they're not allowed to, may not. There's a statutory bar. There's been a bunch of case law about how that applies where what's in play is Part 6. And people were arguing, well, the language of section 23 is that a local authority is required to do under the Housing Act. We all know the allocation kind of regime for social housing under Part 6, and that many, many people will never be allocated social housing under that regime because of the waiting lists and the criteria and the shortage of housing to allocate. So for example, I think it was both Adolo and Campbell, they were arguing that that the local authority is not required to give somebody accommodation under Part 6 because they're never going to qualify. So give me accommodation under the Care Act, if that makes sense. And the court rejected that. They said, I don't care if you're never going to successfully bid on accommodation. When we say required to do under the Housing Act for the purposes of Part 6, all that's required is for them to offer accommodation in accordance with their allocation scheme. And I don't care if you're never going to get to the top of the list. So it's pretty hard reading. And that's why again, the importance of pushing for why general needs isn't going to be good enough. And once you're in that kind of territory, you can say, well, this isn't Housing Act because I need something that isn't on offer under either Part 6 or Part 7. And again, this is the language we get of the courts being really sympathetic to the fact that these are really difficult kind of resource issues. The housing regime is meant to be dealing with that, and you're not allowed to use the Care Act to circumvent those regimes. Other interactions, I'm not going to go into this because we'd be here for ages. Asylum support regime. TMX, usefully, I mean, they didn't need clarifying, but local authorities like to ignore the pre-existing law. In assessing whether an asylum seeker has eligible needs under the Care Act, the local authority should ignore the fact that the Secretary of State might offer asylum support accommodation to an asylum support seeker whose claim hasn't yet been determined. So that's the section 95. So the fact that somebody might get put in a dodgy asylum hotel is not something that the local authority can take into account when carrying out a Care Act assessment. So TMX underlines that. Section 22 is the provision on the interface with health. It's all quite complicated. I'm not going to open the can of worms. There's a little bit in the guidance at this reference about relationships with other services. And I'm just going to finish on my slides with, oh look, the same slide again, with, I don't normally put big quotes and I'm not going to read it, but this is from that section of the guidance. What's really important here is it underlines that social services can't just go, oh, well, you meant to be getting it somewhere else, and then go, not my problem. Unless and until somebody's needs are being met by another system, it's still an unmet need, and social services still have a responsibility. And so they need to be pushing and working with other organisations. It can be useful to point them to this if they're not doing that. Again, they're often quite bad, so whether that actually does anything is kind of moot, but that can be quite useful. So what happens if you, I'm going to take that off because it's like a scary amount of text. what happens if you've done all of these things and you've asked them for an assessment and they've produced a piece of crap, frankly, because that's what you mostly get, unfortunately, with these assessments that says nothing to see here, we don't have to do anything. This is the tricky kind of question that Dominic was talking about. When you get a social care assessment, your only tool is judicial review and challenging that, generally speaking, unless you want to do like local complaints procedure, but and a couple of years ago, Shushin and I at this Chambers tried to challenge the failure of the government to introduce an appeal mechanism, which would have been like an independent appeal route on the merits for social care decision making, and we got absolutely shredded by the High Court, so that's not coming anytime soon. What it means is you're limited to classic judicial review grounds, and we're talking about, you know, irrationality, process errors, that kind of stuff. And that's really, really hard with social care assessments because the court is often quite deferential to social worker decision making. I'm looking at Louise meaningfully because we both have quite long-running cases in these kinds of areas where we know you can often get stuck in a kind of a cycle of PAPs where you say this assessment isn't any good for these reasons, and then they go, okay, we'll reassess, and then you get another one and it's crap, and then you just go again, and it's sort of a war of attrition that can last for a very long time. Even if you get something that's successful, kind of if you get something into court and get the court to agree that their decision making has been unlawful, often it's very difficult to get a mandatory order. It's really hard to prove that there's only one rational thing that they could do in a particular context. It can be a bit easier where they've accepted in their assessment that somebody needs supported accommodation but has failed to source it. That might be more of just a straightforward kind of Section 18, you know, look, you've accepted this person needs a supported accommodation, but you're not complying with your duty to meet needs under Section 18 of the Care Act. What you then hit is the stuff that you get in the housing context where you're saying there's a mandatory duty and they're saying, we've tried, but it's impossible. So you're into the whole imam territory. And that's why it can be really important in these cases, both in terms of getting a care planning document that's actually of any use, but also in setting up potentially a challenge, if you need to, where you're actually going to get relief, to unfortunately do some of your own legwork and try to identify options. Because if you can't get it into the COP and the local authority aren't identifying anything, you want to start reaching out to like local organisations that are relevant to the kind of cohort you're working with to ask if they know anything about what supported accommodation or other services are in the area. So I reach out to, for example, the Challenging Behaviour Foundation if I've got somebody who's autistic and has challenging behaviour and they're being evicted because of that. Or you might be thinking about reaching out to Mind locally or, you know, any of these organisations to say, can you tell me anything about what's available on the ground, to try to start scoping stuff. You might be making kind of requests from the local authority for disclosure of their their brokerage and who they're working with, list of supported accommodation in the area. Anything you can do to identify a practical option that makes it easy for the local authority to do their job because they're not good at it. The other thing, unfortunately, it might be necessary to consider is that sometimes it's worth asking an expert whether, in the event suitable supported accommodation can't be found, whether general needs accommodation with a really, really robust wraparound package might be an alternative as a fallback, and what that might look like. So how intensive would that need to be? Because sometimes you get to a point where you're like, look, it's just not, it doesn't exist. Or at least as far as we can tell, it doesn't exist. Is there another way that we can cobble together something that might work for this person from general needs plus a really robust package of care we can ask social services to put in place? But it's really tricky. These are really, really hard cases. And I know that I can think of multiple cases where I don't really feel like we've always kind of found a way through, but these are the tools that you're going to be using, and you're going to want a good long stay if possible to get all of this going, because it can move pretty slowly. And as Dominic said, if you can get it into the COP, they have a lot more power, I think, to exert pressure on local authorities to identify options. Yeah.
Maybe the wrong word, but they certainly do their best. Thank you very much. As I'm going to ask Laura to finish off, if that's all right.
Thank you, everybody, and apologies for the lack of slides. I think I was I've been asked to talk, I think it's fair to say, a bit more about some of the practical aspects, both in, particularly maybe from the solicitor's point of view, in terms of dealing with some of the kinds of clients that we have that that may ultimately require supported accommodation, and also some of the kind of ways in which you can help get to that point, practically speaking. Particularly, I have to say, I have concentrated on possession proceedings, partly because that's become, I don't know, accidentally really a bit of I guess a bit of a specialism of my own practice. So sorry, I'm being selfish and just sticking with that a bit, but obviously there's a huge overlap with lots of what Alice said in that context, because I'm talking about people who come to you who are in general needs. They've got possession proceedings because of their behaviour, and where do you start, and how you deal with some of the challenges along the way, particularly in relation to capacity, I must say, because in my experience, quite often what we're looking at with supported accommodation, not always, but quite often, is that the person in front of you doesn't actually accept that they have a need for that kind of accommodation at all. And that's one of the first sort of stumbling blocks. I guess I was asked to say a bit about dealing with clients of this kind, and I always feel slightly like teaching grandma to suck eggs in these situations, because we all deal with vulnerable clients all the time. But I thought I just brainstormed a few kind of things that I guess I feel that I've picked up along the way, with the kind of overarching thing about trust, because I think one of the things that's really fair to say about these kind of clients is that they so often have been so badly failed by the system and by all the professionals that have dealt with them, to get to the point where they're losing their home, maybe because of lack of support, that they really struggle with trust issues. And so finding ways to establish your trust with them is absolutely essential, even against the backdrop of potentially having to then decide that they lack capacity. That's a really difficult dynamic, that you're establishing trust with them, but then you immediately feel like maybe you're kind of going behind their back to kind of get somebody else to give you instructions. It's really difficult to think about. And I guess one of the things is just that I think we always have to remind ourselves that we're dealing with individual human beings. I know it sounds really obvious, but we, your head's buzzing with all the things that you need to do in the case. And I really just think that having the human connection and making that person, particularly somebody who lacks this kind of trust, feel that you're that you, if I can put it this way, see them as a person and not as a client. And I think sometimes that's even just little things, like if you pick up that they start talking about their cat or their sick father or something, that you remember those details, that then when you next interact with them, you ask about those things as well as asking for the things that you want to know from them. It might seem obvious, but I just feel it makes a real difference in the sense of them feeling kind of seen and helping to trust them. I think that, like, not being afraid of using humour, I absolutely don't mean taking mickey out of them, but I mean that actually some of these people are so intelligent. I think, it's so sad. I think it's so sad sometimes you meet people, particularly say with, I've got a lot of clients who've got behavioural disorders of various kinds, sometimes quite extreme, and underneath, inside, there is sometimes, there's a doctor, there's a lawyer that if they'd had a different life chances might have come out, and it's so sad. And they're often very funny, and I think not being afraid to kind of grasp hold of that and joke with them. Again, it's about treating them as a human being is important. Obviously, I think Marie touched on it. What's going to alert you to the fact that they might have a need, they might have capacity issues, that they might have a need potentially at the end of the line for supported accommodation, is, I think broadly, a lot of the cases it would be either antisocial, quite extreme antisocial behaviour, or hoarding. I think that that's often the kind of cases we're talking about in the possession context. And as we've touched on in terms of capacity, it's not recognising that the problem, not actually being able to weigh up that if you don't sort out the hoarding problem, you are actually going to end up on the street. In relation to antisocial behaviour, I think the most common one I've seen is often about persecutory beliefs. It's often about thinking that your neighbour is spying on you, and therefore everything you're doing is justified because you're reacting to that. And I think when you're dealing with clients with these issues, then I think you have to validate your feelings, not the facts as they perceive them to be. You can't, be kind of saying that you agree that their neighbour is spying on them, but you have to get behind how their perception that is what is happening is making them feel, and obviously have a deep empathy for that. So that's just some thoughts for what it's worth about establishing your relationship with them. And maybe if in some cases, if you can do that, then you might be able to get a bit of a chink of light where you feel that they will actually agree that maybe they might struggle with having, I don't want to say struggle with reality, but that they might actually see that there might be things going on that they might have an issue with, and be able to persuade them to see an expert to consider capacity. But sometimes it's just not possible. And I'm sure, I know we've dealt with cases with Dominic where it's just not possible. And I was asked to sort of touch on the question of our professional obligations if that happens. So you've got a client who's just they don't want to go on this journey. They don't want to think about alternative types of accommodation. They're fine where they are. It's all the neighbour's fault who's spying on them. And the hoarding is just normal, and and there's no problem with it, and so I just wanted to sort of point to the fact that in such circumstances we may actually end up having to say, often it would be the barrister that was doing this, but sometimes it might be solicitors, particularly on the court duty, that we do have to then think about our obligation to the court, and that there are instances where we have to flag to the court that there is a concern around capacity. And where that comes from is the test that Marie was talking about, where were you? I'm sorry. I thought so the test in relation to the fact that I don't actually think we had talked about, I'm so sorry, that in relation to the fact that the court can't take, it's part 2021 of the CPR, that the court can't take any further action in relation to, no party can take any further action in the proceedings without the court's permission until the protected party has a litigation friend. So if there is a concern that your client is a protected party, that there's somebody who lacks litigation capacity, that has to be investigated before there can be any other steps in the proceedings. And in light of that, there is an obligation to inform the court if there are concerns about that. Now, Dan's not here tonight, but obviously he's the guru of this, and he has been pointing out through the working group on civil litigation capacity that there's not a proper framework from this. So and hopefully eventually there will be, but it's still a bit wild west in terms of, you still feel a bit like you're going out on a limb in terms of our usual instinct that, everything is done at our client's instruction, and particularly that we just don't disclose anything without our client's permission. But Dominic, actually, in talking about this talk, has drawn my attention to some very useful they stressed it wasn't guidance, that the bar standards ethical advice that has been produced by the Bar Standards Board, which is in relation to I'm going to circulate this paper afterwards, everybody, but when I've tinkered with it a bit, but essentially there's some very useful advice in this paper that's around the fact that if you are concerned that your client lacks capacity, and you ask them to, if you can investigate this further, and they reject your advice to obtain further evidence, then the court should be concerned about those concerns. And the Bar Council's view is that the court should be informed, and that's particularly for the protection of the client as well as for the workings of justice in terms of the client may be a protected party and that needs to be explored. But I did also just put, if in doubt, call the SRA helpline, because I've had to do that once or twice because it is difficult. And actually, that's your ultimate fail-safe if you're concerned about your obligations. I mean, just so by way of example, I actually had a client who sacked us before we got to the court hearing, and I had hoped that it would be possible to say, well, I could still go and flag my concerns, and I called the ethics helpline and they said, no, you can't, that's a breach of client confidentiality, and so I couldn't go. So I think that actually illustrates the point that it is a bit of a wild, wild west, because I suspect I might have gotten a different answer from a different advisor.
You would have a different answer from the bar.
Well, yeah. Anyway, I moving on a little bit, I just wanted to talk briefly, assuming that you have got to the point where you flagged those concerns, then what usually happens at that point is that the court will order that there be an assessment, and whether that's that you may have got that with the agreement of your client or not, and you go and get your capacity, assessment, and the way that works is that you're asking the expert that you're instructing, this is about litigation capacity I'm talking about at the moment, to complete a capacity certificate saying whether or not the client lacks litigation capacity. And I just wanted to flag that when you are entitled to share that with the other side and the court, but the underlying report that has been generated to come before the expert completed that, you can only share with the court, you can't share with the other side, because you don't yet have a client to instruct you that you can share that report. Just an important point of procedure. If the client disputes that, you then go to your client and you say that obviously you have to tell them, then the other thing that can happen is that the client can dispute that they lack capacity. It's so understandable, isn't it, that they would, because they're often intelligent enough to realize that what this is about is control, and that they ultimately it's a step in the direction of them losing control of their own decision making. And then you need to inform the court that your client disputes it, because then the court has to make a decision as to whether they lack capacity or not. And usually, in my experience, what then happens is that there's a hearing and the client quite often fails to turn up, and then the court makes a finding of lack of capacity anyway. But I did have one that went on for ages, where the court actually decided that the judge in his wisdom decided that the client did have capacity, and it created enormous amounts of problems for a very, very long time. And eventually we went back again, because by this stage the cop was involved on a different side of things, and got a different judge to make a different decision. But so it can be quite problematic, but you do have to flag that if the client is disputing it. I suppose what I'm doing is kind of going on, just taking through a little bit of a sort of journey along the way with these kind of cases. And so the next stage, if you then got a finding from the court that the client lacks capacity, is to see if there's a litigation friend. In 9 times out of 10, I think, really sadly, in our clients' cases, there won't be somebody suitable. They're usually, by their nature, people who are quite isolated, or if they have got a family member that might do it, then they've got a terrible relationship with them, and so you're most likely looking at engaging the official solicitor, and there is a form that you do that on. And one thing that I would say for anybody who's not had to do it before, that it's a really lengthy form, and it's really important you give it a lot of attention, because it takes quite a long time anyway for it to get processed. And the last thing you want is to be a bit slapdash about it and then 6 weeks later get told, but you haven't addressed this. You want to be as bells and whistles as you can in it, and you absolutely always have to address why you're approaching them, and the efforts you've made to find a litigation friend, because obviously this is cost public money, so they don't want to take it on unless they have to. But then once you've got the official solicitor on board, then you want to be then, I mean, that's the point at which you can kind of you can start doing, in these cases I'm talking about where somebody lacks litigation capacity, where you can start doing some of the things as early as possible that Marie was referring to, in the sense of preparing the case. What you're trying to do is prepare the case essentially for being able to say that this person may well need to be evicted from their home, but they mustn't be evicted onto the streets. There must be an alternative that's identified. I think that one of the things that there's been some things mentioned about front loading things. I mean, one thing I'd suggest is getting the social services records as soon as possible. There's usually been some involvement. I mean, I think it ranges really widely what the involvement of social services might have been. So social services might have tried to give some support, say, to somebody who's hoarding, and then quite often they'll, oh, you refused our support, and like Alice was intimating, they then just give up. They may not have been involved at all. They may have not looked at anything to do with capacity to make decisions about housing. In fact, I think they quite often haven't even thought to do that. But it's useful to get the file, because there may be some old Care Act assessments that you want to look at. You want to know where you want to start. Are you asking for a brand new Care Act assessment? You know, are you just referring for that, or are you actually challenging something and saying a new one needs to be done? So getting the file can be really helpful. I think I was sort of also asked to touch on this stage. I wondered how many people in the room either do community care in their practice, or have a community care practice within their firm, or in chambers. Like, yeah, so there's a few, which is probably not surprising because it's a bit self-selecting because of the topic, but actually even then there's not that many of you, and I think that those of us who have housing law practices will really know that this illustrates a really big problem, in that it's just absolute awful advice desert in community care law. So one thing that I wanted to just talk about is some of the ways that I've sort of dealt with kind of getting around this a bit in terms of what you can try and do under your housing legal aid certificate to try and push some of these things along. I have to say, I have often done that without much of a nod to whether or not we're going to get paid for it, because who cares? Ultimately, if they're not going to pay for that letter that took you an hour, I mean, in the context of things. So, I mean, I've often just, with guidance, hopefully from somebody like an expert barrister like Marie or Alice, who does do community care, you know, just sent a PAP under the housing legal aid matter. If you've got a public law contract, then you can also do it under that. But there's going to come a time, I think, particularly when you're starting to deal with things like we were talking about court of protection and getting you know, a PAP might get you a Care Act assessment, but in terms of the issues in relating to making application to the COP, I think you really want to try and find specialists. And one thing I would say is that if your client's found to lack capacity, then it can be really useful, because those comp care solicitors among you, I think that the official solicitor rings you up and you probably find time to, in my experience, it's an easier way to identify a community care solicitor. If the official solicitor does it for you, they probably have their preferred contacts there. I think the final area that I wanted to talk about in this context, which I think it was mentioned earlier, is about it's kind of a less adversarial approach. It's something I really quite like to approach, and we've done it before, Dominic and I, on cases, is how else to get social services involved and start looking at the process of looking at supported accommodation, apart from, I mean, you have to do it alongside these things, but I think that you will often find that you're pushing at an open door if you start suggesting, particularly to social landlords, having roundtable discussions, multi-agency meetings, whatever you want to call them, in order to try and get everybody in the room, and perhaps having a stay for that process. If you think about the motivating factors for that, I mean, you could be cynical and you could say that the landlord is able to say at the end of the case, well, we looked at lesser measures because we went to a multi-agency meeting and we talked with social services in that meeting and we got them to come along. And so it helps them tick that box. But it also does save the cost of trial if it works. And I'll talk a bit about it because I do think it often can work, and there's some things that you can do to help it work. And actually, honestly, I do believe some landlords really do want to do the right thing and they don't want to see their vulnerable clients on the street. But we're talking about people who, you know, where there's a need, that appears to be a need for support, a different type of accommodation, and they may well have tried other things and it's just not worked. So in terms of multi-agency meetings, I think it's, as I say, I think just suggesting it quite early doors to the landlord as an approach, and just you know, you on an open basis, and just saying, think in the context of trying to look to explore what other options might be available, and getting along the Social Services Authority, homeless prevention officers, if there are other relevant professionals like drug and alcohol workers, probation officers, that kind of thing. And to discuss the options, and I have actually found that it can be really, really productive. I mean, we've got, you know, you might, as part of that process, trigger the Social Services Authority to do the assessments they need to do. Sometimes they do respond quite well to that, and it's just one other thought about it. If you're struggling to get people to agree to engage in any process like that, it is also thinking about safeguarding, because Marie, I think, had talked about the fact that that you in terms of triggering an assessment, that can be a way. Actually, sorry, it was Alice. You can, in triggering assessment, if you're mentioning about safeguarding, like because of self-neglect, well, the other thing is if you've got somebody really, really vulnerable, who I'm thinking maybe potentially sometimes like a victim of somebody that is a victim of domestic violence, who might have mental health problems, then you can get the parties in the room if you trigger a multi-agency the MARM process, because this is just one of those levers where people do really sit up. I mean, you obviously can't just do it willy-nilly, but if there's a significant concern about somebody safeguarding somebody, I'm thinking also sometimes actually some of the most like dreadful clients are also the most vulnerable, right? Because they put themselves in harm's way. They're so they can be so on the face of it aggressive that they end up becoming victims all the time because of their behavior. So that's a safeguarding concern if somebody's behaving like that in their property, and therefore putting themselves at risk by their own aggressive behavior. That kind of thing, you could potentially trigger a multi-agency process through that, and I think that's a really good thing to try and do. And I think that's more or less my rambling over, but I just wanted to come back to one thing about dealing with these type of clients that I kind of missed, but is relevant to the kind of client I just talked about, which is that these can be really, I talked about some of them being really funny, but sometimes they can be quite terrifying individuals, right? And they can really vent at us, and they can really, you know, use us as a punch bag. And I'm absolutely not, particularly as an employer, saying that we just take everything, and we have to have safeguarding procedures for staff in place. But I just think that we're often just like the last people that will deal with these people at all. Like the number of times you get mental health professionals who have closed the door to services because they say, well, you phoned up and called me a cunt, you know, excuse my French. It's just unbelievable. And then you just think, and I remember saying at one point, you know, like I'm sure we're all like this, yeah, exactly. Like if we closed the doors to every client that swore at us or even threatened us in the height of their agitation, then we wouldn't, I wouldn't have a practice. So I think that there is an element of we all have to be resilient to it. I'm absolutely not saying that we put ourselves in harm's way, and I think that we have to make sure that the processes are there for assessing the risk. And I very firmly believe as a manager that, you know, if you've got really volatile clients like that, then they need to be assigned to, you can't just leave them with the paralegal who's just joined. You have to be really quick on it to kind of say, no, this person calls only come through to me about this person. But that then once the right person is dealing with it, then you do put up with it. So much of the time it is just venting, and they've not been able to do it with anybody else. I had a client the other day who they had injunction proceedings because he was invited to share his frustration with his housing officer. She said, you know, what is it that's troubling you? And he'd had massive disrepair for years and years and years. And so he vented, and okay, he swore a lot, and he said a lot of quite fruity things about what he would do to various like operatives, and then he got injunction proceedings slapped on him. And we're not those people, right? We take it on the chin and we hear them out, and so often at the end, actually, that's a way of winning trust, just allowing them to vent at you. And often they'll say at the end, "I'm really sorry," and they'll say, "I don't. It's not about you." And that's just another thing that you can do to build trust, is just allowing them to do that within reason, of course.
No, that's brilliant. Thank you. We do have time for questions, but I did want to thank all three speakers for that, particularly Laura, who has brought home what my innocent questions. Could you just find this out, please? Or could you just do what actually that means at the coalface? So I'm always very grateful. We do have time for questions. I know that there are some online, and if anybody online wants to post their questions in the Q&A box, I will try and deal with them. And if there's anybody here, we do have a microphone running around. I see that immediately a member of Doughty Street Chambers is putting their hand up.
Sorry, I was quite. Thank you. I was quite excited for this session because these cases come up so much, and I feel like it's a lot of muddling through. Sorry for the big question, but can someone try and outline a bit what you can take to the COP, when you can take it to the COP, and how you get there? Because I think it's still sort of quite unknown territory for a lot of housing lawyers. When's the COP the right forum, and what decisions is it the right forum for? Particularly given the difficulties with JRing problematic Care Act assessments and things like that.
You're all going to advocate on this, aren't you? Thanks so much. The COP is a very, I mean, firstly, it's a jurisdiction that has a jurisdictional hoop, and that is you can only get there if you if your client doesn't have capacity. But of course, it is for the COP to decide that. So there is an investigatory process about it. So from your perspective, it's if there's a possibility of it. And it was interesting looking at the case of Tame, how much it was all about, well, we're not sure if that really is going to work. The case of Stevenson, which was not a capacity case, but was a case of antisocial behaviour, and there was noise going on, and the Court of Appeal said, well, look, you haven't tried all these other options. It didn't say these other options won't work. It said you haven't tried these other options. You could have thought about putting sound insulation to stop the noise traveling from one flat to another. So the point about the discrimination defence is that the trigger that could potentially get you to the COP is not so much will this work, which is why I don't like the case of Tame. It is much more, have you tried this? Now you have to show that there is going to be there's a reasonable prospect something might come from it, but you don't have to show absolutely that your client doesn't have capacity. You do have to show that there is a reasonable prospect that the court will of that case, and that the court will look at it. So if you've got an expert that says, no, this person doesn't have capacity, fantastic. But if you've got an expert, for instance, who you had a very reluctant client, you couldn't get an expert to actually see them, but the expert does a report on the basis of paper documents, for instance, what the GP had or what the local trust had on their records, you might not have an answer, but you'll have enough to get there. So the first thing I would say is, although jurisdictionally, it's only for those who don't have capacity, but that could cover quite a lot of people who do, but still the court is unsure about it. So it's an option you think about. You had two other parts. I can't remember what they are now, but I think one of them was, well, what can the cop do if you get there, and how do you get there? And so you've got to have that evidence that puts everybody on notice on capacity. But in terms of getting there, it is about stays. And if you think about the process of the, let's take the hoarder case or the antisocial behaviour case that Laura was describing. I feel for you, Laura, as you described that. You will be wanting to talk about all the things that Alice has said. You'll be wanting to shout at social services, you haven't done an assessment right. Here's a pre-action protocol letter. You will be wanting to say to the landlord, you haven't tried COP, have you? You're a local authority landlord. You should be thinking about that as an alternative. So the next question is, having pushed that right from the beginning, why are you talking about COP? And that's because you recognise in your, for instance, your defence of a possession claim, you recognise that you're probably going in a situation where you're going to be going to that last resort. All right, it might not change, but you should be providing suitable alternative accommodation because this person is so vulnerable. And of course, that begs the question, well, what's suitable alternative accommodation? I think the title of this talk was supported accommodation. Let's call it many types of supported accommodation. But that's why we've as it were, we've talked about today all the various options and how you might go and find that alternative. And it is going to be in that context that Marie described, where you really are, you know that this client is going to be possibly evicted. And if they are evicted, you want to know that they're evicted to somewhere. So your argument is it's not proportionate without having somewhere. So your argument is you need to stay this case until such time as you've investigated through COP what that might be. What's COP's jurisdiction once it has jurisdiction? What's its purpose? Its purpose is to make choices between options. Well, that doesn't sound very good because you haven't got any options. Well, the point that Marie was making is that the COP will shine a very heavy light on the local authority. It can join whoever it wants. So landlord makes an application, you make an application. It joins social services. Even if your landlord isn't anything to do with social services, it'll join social services. Oh, we've got this problem, it'll say to the local authority. We don't know what options are available. Could you investigate them? And what the COP is really saying is, we know you have Care Act duties, Alice. We know that there are potential options out there. Go and tell us what you might come up with. So they have to go and perhaps redo their assessment without the need for a JR. Having established that they're eligible needs, they then have to work out how to meet those needs. And they come back and they say, we couldn't find anything. Alice, I think you mentioned that one. And at that point, you potentially have a JR, or the Court of Protection says, oh, I'm not so sure. Perhaps you want to redo your assessment. Tell me, what would happen if you reviewed your assessment? It doesn't say, I'm obliging you to do it. It's, what would happen if you reviewed your assessment in the light of some additional information that the official solicitors just told me about, at which point they have to go and do. And they know they're going to get dragged back to hearings all the time. And they know they're going to have that light shone on them. Doesn't always work. But the point is that in order to work out which of two best options they should go to, you need to have options. And the court says, find me those options. That's what drags, or at least that's what drags social services into action. So I don't know if that answered your question. I'm hoping it answered your question. Tell me what I missed.
I feel like it's given me a million more questions, but I'm fortunate enough to work with you guys. So I'll pin you down another day and let somebody else ask, I think.
Any other questions?
Hello. Related to that, I had a case previously where the landlord was a housing association. We knew the client didn't have capacity. The OS was litigation friend, but it was difficult because the OS didn't want to go to the Court of Protection, and the landlord was very aggressive, had very aggressive legal advisors who just wanted to get rid of our client. So what if someone refuses to investigate that and the OS doesn't seem keen because of the cost risk, are we just stuck really there?
So the reason why Marie referred to Tame, I don't know, do you want to, no, don't you dare. Okay. The reason why she referred to that case is because prior to that case, you would be saying the landlord is the person who should be making the application, because the official solicitor will just, you'll have a nice little conference with the caseworker, and the caseworker say, all right, I'll ask, and then 5 minutes later, no. So now, in fact, there are occasions when you can persuade the official solicitor to do it, but they're very rare. And the main reason for that is that they will not do anything unless their costs are covered. And that means generating a certificate with the right solicitor, etc., knowing who to refer to, as Laura described. But in the case of the context of a possession case, it's always the easiest one to describe. In the context of a possession case, you've put in your discrimination defence. It says you might, that at the very least, we want suitable alternative accommodation before you evict us, and we want it identified. Local authorities say no. So you're left with a landlord who has no connection with local authority. It says we've sent as many letters as we possibly can. At that point, the option you're going for, particularly in relation to COP, is right. We do think that the only alternative, proportional alternative, is for you to apply to the COP in order to ascertain what options might be available from social services. And this is why it works. If you look at Tame, which said, well, that's not good enough, there was very little information, to my mind, in front of that judge about what the COP could do and what the purpose of the COP was, and how social services would react to the COP when it got involved. So I think you really do have to address the issues in Tame, one of which is to get in early. The second of which is to have a very clear plan about how COP will work. And the third is, the trigger point, I can't get the officials to do it, is to say the landlord only has to apply. Once it applies, once it's in COP, they'll practically become a silent partner. They'll, in fact, in COP, there is such a thing as a silent party who just sits there as a party but doesn't actually do anything, doesn't come to hearings, doesn't make representations. They're there because they may be relevant at some point and information may be required of them. But so it's, again, taking Tame. Why should the landlord spend all the money of going to COP? It's not a big deal for that landlord to go to COP in reality, because what will happen is the COP will get hold of it, they'll join the local authority, and they'll make the local authority the applicant, at which point, and they'll get the OS involved, at which point you're away. So that is a difficult hurdle that I've just described. Anybody listening to it would know that, but it is still the only strategy available at the moment. So you have to get around Tame on the basis of, I think, better information about what it can do, and better information about the plan, and a much clearer reason for saying the possibility is a good possibility. I do not have to say, in order to persuade the court to reject the claim, the possession claim, I do not have to say that it's a certainty. I only have to say, this is a case of Stevenson, that it's a possibility. Doesn't mean it'll win next time. Any other questions? Please, question for somebody else.
Hiya. I'm going to change topics slightly, if that's okay. I had a question about section 23 and the interactions between housing and care, and specifically sort of circumstances in which the client comes to you where they're probably already owed duties under the Housing Act. And so they've come to you as a housing client, and you're, I guess, one of the first people or the person who identifies that general needs accommodation is not probably suitable, but they're already owed duties under the Housing Act, whether that's the main housing duty or the relief duty, and how that interaction works, considering the prohibition, if that's the right word, in section 23?
Yeah, I think what you get under the Housing Act is general needs accommodation. There are so I think you can look at that and say, well, what is the local authority? The language is required to provide under the Housing Act. And if what they're required to provide is in no circumstance going to be suitable for your client, you hit the boundaries of, there are debates to be had about whether you could push the suitability requirement out to get something specialist. But I think most of us function on the assumption you're not going to get supported accommodation through the Housing Act route. Then I don't think Section 23 bites, because what you're saying is what they're required to provide as general needs. What my client requires is supported accommodation. So Section 23 just doesn't bite to prevent the social services authority from providing accommodation if you can show that there are eligible needs and that they're accommodation related or hit the accommodation plus test. So that's how I think about it. Do you agree? I know that Jamie in Chambers here has all sorts of interesting thoughts around what you might be able to push through Housing Act, but I think it's tricky.
It's difficult.
Yeah.
There's no question, and it requires somebody else to look at the cases and think slightly more widely. And by that I mean a judge, and by that I mean the Court of Appeal, the Supreme Court. So I think you're in. It is dangerous territory, but yeah, I would follow that.
I would be saying social services, I can't get what I need through this route, therefore it just doesn't apply. Often, I mean, it's only if they bring it up. I wouldn't flag it to them. If they come back and say, I'm not going to give you that because your client already has, then I guess there are sort of two routes you can go. If you're absolutely sure it's only going to work with supported accommodation, then you need to really push them on that. You will want to think, as I say, in parallel, because of the difficulties sometimes in locating suitable supported accommodation, about what a very robust wraparound package and general needs might look like, and also how far you can push the limit on your housing needs assessment, say under Part 7. So you might be looking at, this person needs to be in a place where there's, not lots of neighbours, or, XYZ, to try to mitigate as far as possible, and then a care package with that. So thinking kind of creatively about what combination of factors might create an environment in which that person has a better chance of kind of managing their tenancy and just sort of their day-to-day life. Yeah.
Laura, you
I suppose one of the things that it might lead to is potentially a suitability review. And in that context, you could then get an expert report where you could try and get the ammunition, which you could then use in relation to social services. As somebody that it's currently still, our area is still not a unitary authority, which is probably an alien concept to most of you Londoners in the room, but it's particularly difficult, can I say, if it's not a unitary authority, because it's absolutely, they will want to bat it back and forth because it's completely different budgets and completely different councils. So there's that to consider in potentially kind of letters, doing PAPs that you are copying to each local authority to put the pressure on both of them. I mean, I did just want to say that I think it is also quite useful to try and know as much as you want to. We touched on it before about the local landscape in terms of what's available, because there will be other things that the local authority housing department can refer people into that isn't provided through it doesn't require a Care Act assessment. I mean, quite a lot of the charitable providers for mental health, like a big Mind being an obvious one, they don't necessarily, they can be done through referrals from the housing authority. So in which case you don't have to pass that threshold anyway. But I think it's probably knowing what's available and knowing as specifically as possible what your client's needs are by finding an excuse to get legal aid. Under legal help, of course, you can do it as well, funding for a report, that whether it's psychiatric or OT.
The experts report, that opportunity to get evidence and focused evidence on effectively showing why general needs doesn't work or whatever it might be, is definitely worthwhile. I did want to mention one other, where you mentioned drafting pre-action protocol letters. We've used witness summonses or threats of witness summonses as you're sort of chugging along in the proceedings, and I have used threats of witness summons, to social services, for instance. Which witness are you going to send along to answer all the questions as to why you're not doing so well on the social services front? And it sometimes works, it sometimes doesn't, but at least it's evidence in the county court, and it's a way of applying pressure. And on several occasions, very close to hearings, when they realise that awful witness statement they put in is going to get cross-examined, they do start suddenly saying, okay, well, we might be able to do this. So that's one other means, but it is Nothing is a bullseye, which is what's so frustrating about this area, and which is why this whole topic has been quite broad in the way that we've started it, if that makes sense. Any other questions?
Can you go under the Court of Protection contextually?
I'm going to ask you to speak up slightly. Everybody else may be able to hear you, but I'm almost
Sorry.
deaf, so.
Can you go under the Court of Protection contextually, given that it's incidental? The assessment is incidental. Can you go under it contextually?
Explain what you mean by.
So can you go under the Court of Protection for a specific hearing or for a specific proceeding? I mean, I understand that it's civil and you get a civil cop ticket, right? But can you do that and then withdraw it, basically?
Do you mean in terms of legal aid, or do you mean?
Well, just in terms of if you have a client who, for example, is really struggling with one aspect of their care, doesn't want to go into hospitals, to go into like mental health act, all of that, prefers a different route there through social services, but in housing doesn't want that freedom to be taken away from them.
Remember what I suggested that the COP can do. What it can really only do is it can make decisions between choices. It has other duties as well, but the way in which it discovers those choices is by focusing on social services. So it's still it's really a route to social services as such. So you're always ultimately thinking about trying to get social services to help, because they're the only statutory body who have potentially the money. Okay, they have no money, but potentially the money, and nobody else is there to do it.
So like once you're in under the Court of Protection, you're just under the Court of Protection. Each
jurisdiction has to have it. So whether you go to one place or another, you have to go there with the purpose of trying to achieve something that court can do. And I've suggested that the way you do it with the Court of Protection is you say, well, we know that this accommodation is about to be lost. There are possession proceedings. We're going to the Court of Protection to discover what options are available and which of those options is in the client's best interest, which is ultimately the decision that they make. But
thank you.
It's a route really to getting that help, and that's JR may in some circumstances be the better route. And there's a reason why Alice is so good at what she does, is because there are so many cases that she's having to deal with. So JR is still very much a route, but you're trying to think of as many ways of applying that pressure. I don't know if I answered the question. I hope I did, but you may have a better.
Sorry, I'm sorry, it's probably not an answer to your question, but I was just reflecting on what the thing about what the COP can do, because slightly unusually, I've actually got a case at the moment where the case was already in the COP actually, and the landlord slightly unwisely decided to bring possession proceedings anyway. It's all a bit weird because they've carried on with the possession proceedings, but in the meantime, in the COP, the Social Services Authority has got wraparound care for this hoarder, and they're coming, and they've got people coming in. I think it's every other day or something extraordinary. It's an absolutely extraordinarily bad hoarding case, and I think that the reason Social Services got involved was because he kept being evicted from accommodation after accommodation after accommodation, and then they finally realised they were just going to have to bite the bullet and do something pretty extreme, but like so this guy is in his general needs accommodation, and he's got this massive wraparound thing to help with hoarding, and as I say, unwisely, the landlords are still continuing with possession proceedings, which we're just actually finding quite funny at this point, because I cannot imagine any other outcome at the end of it than that the courts can say, well, what on earth are you doing? Because we've got witness evidence from the social worker that says that the arrangement is working, and they've just not got so it's just ridiculous. There's this sort of slam dunk disability discrimination case at this point. So that's I know it never works like that because they don't normally do that, but that's ultimately what you might be able to get them to do. And that's obviously, this is almost like you were saying about general needs plus solution as opposed to supported accommodation. But yeah,
I'm not sure. I might have also misunderstood the question, but if the concern is, do you get to the Court of Protection and then everything's at large? So medical and welfare, and then residence and care, and then finances. Is that what you meant? Got you.
Agency approach. So then the multi-agency approach imposing that upon a client who doesn't want aspects of it, obviously.
Got you.
Because, you know, even with disability, like you still should be able to get to choose which aspects of care you want and which aspects you don't.
I think it will really, well, that's for Dominic, I think, but again, poor man, because that's really outside of my area in terms of, but it should just be really a question about each thing that they lack capacity about. So it's issue specific. So they shouldn't be worried that just because they're being rushed through the Court of Protection, because they've been, you know, evaluated and assessed to lack capacity to make decisions about residents, that every decision that they're going to make is now under the scrutiny of the Court of Protection. So I think it's, we may be thinking about people taking certain medicines or mental health interventions and things like that.
Actually, yes, it is. It can be contextual.
Yeah.
Okay.
We've got 5 minutes or a few minutes left. One more question, or maybe two. We've got 2 questions.
This one for Laura. I was just wondering about your Comcare point and going to the COP, and whether we could get round it as housing lawyers under legal aid if you don't happen to have a community care contract, which obviously a lot of housing lawyers don't. So I think, like, traditionally, most applications to the COP are going to be under either a mental health or a Comcare contract. But we're going to come across it almost always in the context of possession proceedings, which potentially being stayed, and then the outcome of those possession proceedings become dependent on what happens in the COP. So I had a quick look at the 2024 contract and its category definitions, and it does say that there's overlaps between categories, which this would be. And then, like, so I think paragraph 5 of Schedule 1 of LASPO is the Mental Capacity Act. Paragraph 33 is the one for civil legal services for possession. And that just says civil legal services in relation to court orders for sale or possession, which is pretty broad. Can you not argue? It's certainly worth arguing, I reckon, if you can't find a Comcare lawyer that's going to take it on, or particularly if you're talking about cases where you've got a joint judge who's sitting in both capacities. What point is there having a different lawyer dealing with that judge when he's wearing his court protection hat, and a different firm dealing with it when he's dealing with his possession hat on? I don't know. I'm pretty sure we used to do it under our housing contract in the past, but I don't know if anyone else has tried.
I haven't tried. It is a very good point, and I think that probably, I mean, as long as you're making sure that you're applying, you know, you probably want to specifically approach that with the legal aid agency, wouldn't you, on your certificate, and then you were explaining it all, then I can't see why it wouldn't be worth trying, but I haven't tried. I mean, I wouldn't want to go too much out on a limb with it without getting, you know, whatever it was you needed in terms of the scope limitations, but it sounds worth a try.
I've been, it might not be the same thing, but I've been ordered by the Court of Protection to come as like a housing consultant. I mean, I was the housing barrister in the case, and I was paid to do that, and nobody ever disputed that, because I disputed it because I was like, why am I here? But it was helpful because they were doing all sorts of strange things. But yeah, I think they can be quite broad about it. But whether you'd be able to make your own application to the Court of Protection under housing contract.
There are 2 things. Will, I think you were asking really about what does the legal aid contract allow you to do. Though the only alarm bell would be, I can't remember whether it was JR contracts or whether it was housing contracts couldn't do one. Probably JR couldn't do 204 cases or something like that.
It was a case on a public law contract only, and they couldn't do a 204 appeal. Yeah.
And I remember that somebody paid a nasty bill as a consequence of getting that particular line wrong. I'm
just wondering, I know that there's a community care lawyers kind of forum. I'm looking at Louise because she's way more involved than me, that are in kind of conversation with the legal aid agency around at times around various issues arising about the way, for example, legal help works, or like investigative help for Comcare cases. And it might be that this is something that might be worth opening a conversation about, partly because the logic to me is that it should actually reduce costs because you're not duplicating across firms. And I also think when we're talking about really vulnerable clients, it really bums me out that we end up, you know, you've spent all that time building trust. And then suddenly you're like, actually, we need to bring another person in. These are often people who struggle to engage with like multiple people. It doesn't make any sense. And the times that I'm instructed, I mean, I've had cases where I was instructed across 3 different areas of law by 3 different law firms. And it's a bit of a nightmare as a barrister as well, because they all have different sets of papers as well. And like, you really see how much falls between the gaps. So if there's any way that we can convince them to let us do more of this, and I think it would save them money, it would be great.
If you tell them that it saves you money, they love that.
Yeah, exactly. I'm speaking their language, right? So, yeah.
My only other question was, as you've got a piano behind us, are you going to be like ending the show with a song?
Famous policy, yeah. Top 6. Me and I think I'm going to do it.
Last question, and then we're done.
Just a quick question. I might have misunderstood, but you said that COP is a route available. JR is an alternative, but how does that sit with JR being a remedy of last resort? Like, what's the interaction?
Because COP is not answering it and will never answer the whether or not somebody's care plan or assessment is unlawful. It will simply say, "Oh, is that right? Is that right?"
Okay.
Can you, I'll tell you what, I'm going to ask you to come and explain that to me on the next occasion in the witness statement. Is that all right? I'm not saying you're right or wrong, but I just want to know what you've got to say about it in a little bit more detail. And they go away and they go, "Oh God, we've got to explain to the judge." And they come back with slightly more information. So it really, that jurisdictional divide is very, very important.
Yeah.
And is observed with quite a bit of clarity.
There's good case law on the alternative remedy stuff about it needing to answer the legal question. It's not always observed by courts. Sometimes they do focus on the kind of practical outcome, but there is sort of, if you get out for them and open that bit, you'll get the kind of cases you need to say, as Dominic says, it's just answering a different question. So, yeah.
The local authority on those ones that I've done, the Comcare ones, they're normally more concerned about ombudsman routes and all that sort of stuff.
Yeah.
I've never seen them raise anything about, which is also silly, but has been paid a bit more attention to by
a year and a half later.
But I think one thing I will add, just because I don't know how familiar anyone is with the Court of Protection, and it was fun for me to see when I got to sat down and be creepy, is as Dominic says, they will get social services. They will come and get them. They'll make them write a very detailed witness statement, and then they will sit in front of a judge and have to explain themselves. I mean, how often? You're only ever going to get that at trial if you've got a witness summons and all the rest of it. It is so useful, and they are genuinely embarrassed. So, like, if it's available, if you can make movements to get yourselves there, it is so useful.
But the caveat goes back to Cara's question, which is, what can the Court of Protection do? You have to be able to show that there's jurisdiction, and you have to be able to show that there is a decision that the COP can make, and that all that the COP does is make decisions that people cannot do for themselves. It does not create solutions that they could not create for themselves. So all that they're asking social services is, what are the potential options? What would the client have to decide? And then I will make the decision for P. I think we have definitely run out of time. We've gone over 5 minutes. Can I ask you to show your appreciation for the 3 speakers? Brilliant. And thank you for all coming. And a reminder that part 2, if you can cope with part 2, I hope you can, is 11th of June. We'll put more details out about that, and it'll deal with possession cases. Thank you very much. There's food at the back. Please join us. No, thank you. Oh, that's absolutely.
Thank you very much.